lawyer. Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. It's Tuesday night, which means we're going live. I apologize. We haven't been able to do it for a couple of weeks because, well, I've been in trial. So we can talk a little bit more about that later. But, you know, it was a good result for the guys in the white hat. That's right. The defense team for the Reich law firm came in and got the big win. Let's just put it that way. It was a big win. We'll probably talk about more in our Patreon show as well. But we have a lot to talk about. We'll give it a couple of minutes here, kind of see how many people show up and want to do it. I know we put this out there, but you never know. You never know how many people will show up. Sometimes it's going to be a couple hundred. Sometimes it's several thousand. And since we're going to talk about the Bryan Kohberger hearing that's going to start tomorrow and a lot of the motions that are going to be resolved, and as if you've seen the video today, the stage will be set, ladies and gentlemen. The motions hearing, probably one of the most watershed or defining moments of a trial, is when legal issues are decided. That's what judges do. They're supposed to decide legal issues. Juries decide questions of fact. Judge will decide what, if any, of these text messages are going to come in. What, if any, of these self-authenticating documents from various corporations and things of that nature are going to come in. It's pretty easy for the government to get those documents in. Just about everything can be self-authenticating these days. Not like the good old days when you actually have to bring people in, or the prosecution thought that they had to bring people in. But now they don't want to spend the money. So everything is self-authenticating documents. And you don't really get the opportunity to cross-examine the people that are familiar with those particular documents. But hey, it's a business record for the most part. It's supposed to be accurate, made contemporaneously, and kept in the normal course of business, so to speak. So that is what the court will be deciding. That is legal issues. And like I said, the jury will ultimately decide whether Bryan Kohberger is the individual who committed the burglary as well as the murder of 4 young people there in Idaho back in November of 2022. Can you believe it's been that long? So yeah, that's going to be interesting. All right, so it looks like we're picking up steam here, and so let's get to it. So we have a lot to talk about. First, we got the Bryan Kohberger case. And well, I guess really first, we'll briefly talk about the Lori Vallow trial that's going on. We're stringing it to you live. We'll also briefly touch upon the Karen Read trial. Here's the Karen Read trial update. I don't know. I guess we got it. I guess there wasn't a jury by the time we did the live today. I don't think they got a jury yet. Some people are really into that case. Other people are so sick and tired of hearing about Karen Read. I don't know. Maybe it's just me in that case, but it just doesn't seem like the defense has the same swagger that they had the first time through. Maybe it's all those phone dumps that they got at people, and maybe it's not going to be as easy this time around. And or like I've been saying since last July, the defense had their one shot. They weren't able to convince everybody, that the government had failed to prove their case beyond a reasonable doubt. And so, the prosecution always fixes their case. They got rid of their lame district attorneys. They brought in this Brennan guy, whether you like him or not. He's experienced, he's good, and he is trying to dismantle the defense case. And he's done, a pretty decent job of taking an axe to their case. And we'll see if they actually, have as much success. All right. Then we have Lori Vallow. All right. She's representing herself. I said yesterday, what's the word I'm looking for? She did better than I expected. And when I say that, it's not like she's some great trial lawyer. She's not. And I think her performance is actually going down if you've been watching any of it today. I had very low expectations, so I said she did better than I expected. And when I say that is that I expect expected her to get up and start talking about dark spaces and dark people and all these types of things. But she apparently has snapped out of all of that. And, like I said, she sounds like she is competent, not necessarily competent to be an attorney, although I would say she's probably like moot court competition, high school level stuff. She's asking too many open-ended questions to the officers and all these detectives. No, it's cross-examination there, Lori Vallow. You tell them the answer and you frame that question so that they have to agree with you. That's what you do. You're asking too many open-ended questions. You're killing yourself. You're just not, you're giving them opportunities to not help you. You tell them those shell casings were exactly 4 feet away. You've got the piece of paper in front of you. Why are you asking him what the distance is? You tell him. It's cross-examination, right? Prosecution gets to ask open-ended questions. That's why it's so easy to be a prosecutor. What happened next? What are your job duties? What date was it? Was that then in the city and county of blank? Yes, it was. And then what did you do? And when they really get stumped, they say, and what happened next? Was there anything else that you did? And then they move along. The defense, man, you don't want to get up there and just regurgitate what they just talked about unless there's something good for you. You want to drive that point home, but you want to ask the questions that the prosecutor didn't ask, right? To make it look like they're hiding something, because they probably are. It's called bad facts for the prosecution. I have said, and I will say it here, I've said it in voir dire, in jury selection. If this is some quest for the truth, I should never have to get up and ask a single question, because the prosecutor, in their quest for the truth, would ask all the questions, and I would have to say, no, I think they covered it all, Your Honor. No questions here, right? But they don't. They're advocates. They're advocates for a particular side. That's what attorneys do. And if anybody thinks that the prosecution is somehow holier than thou, looking for the truth, justice, and the American way, all that kind of stuff, that's nonsense. Yes, they have ethical obligations. They think that, they believe they're victims in every case, right? They believe that they can prove their case beyond a reasonable doubt because of the government. They're supposed to be able to, right? They have all the resources. They have all the good facts. And then the defense has to come in and, deal with not that many resources. Usually your client has put himself in a very bad situation. He or she has put themselves in a very bad situation. Okay. And then you got to work around that. And so the prosecutor should win. But if you think that they're, pure as the driven snow, never just want to win, no. And you want to see the true colors of a district attorney, all right? When they start realizing that they are losing, they start to cheat, okay? Everything that they say they wouldn't do, they shouldn't do, they start doing it because they want to win. Because at the end of the day, attorneys are very competitive people. They want to win, right? They hate losing more than they like winning. And yes, you ever seen a DA, when they walk out and say, oh, shucks, that was a great day. I'm glad the truth came out, all that kind of stuff. They never do that, right? So let's just be realistic. I'm trying to be realistic. There's lots of good DAs. Seriously, there are. There are a lot of good DAs. They truly believe that they're doing the right thing. Sometimes they're wrong. Sometimes they're mistaken. Sometimes they get a little more mature and they realize that, hey, not every police officer is on the straight and narrow. Maybe not all of their victims are holier than thou. They, start to get a little more realistic as they get a little more experience and they get burned. And so they start, realizing that, in the world of criminal justice, there's rape, murder, and violent crime. And then there's everything else. Everything else should probably be resolved. And the trial should be literally, you go to a busy courthouse and you look at their trial schedule and it's, murder, sex assault on children. Those are the trials that they have booked up. Violent crimes, No, not that many people do, low-level drug felonies. It's usually the bigger stuff, like cartels and organizations, things like that. Motor vehicle thefts usually don't go to trial. Eludings, like I said, small level drug stuff. That's the way the criminal justice system should be. Save it for the serious stuff where people are really going to, there's possibility like they're going to prison probably for the rest of their life. Okay. So let's get into it. So I think we covered Karen Read. Like I said, some people, I don't know what. You're either in the Karen Read is completely innocent or the Karen Read is completely guilty camp. I don't think there's any way of persuading anybody. Not that I'm trying to persuade anybody. I just telling you generally, her attorneys blew it the first time. Okay. I mean, you got one shot. And I think, everyone says, oh, they didn't give a shot. No, they could have said, Judge, let's ask the juror if they have reached a verdict on any of the counts. The judge could, all they had to do was ask. And the judge said no, then they got real appellate issues, right? But this argument that somehow they agreed and it wasn't official. That argument is going nowhere. Just like I predicted it would when they first raised it. I think shortly after the trial, everyone's like, "Oh my gosh, he's going to be found not guilty. It's going to be no." The prosecutor blew it. The judge blew it. The defense attorneys blew it. Okay. And I'm not throwing stones. I'm just saying they all blew it. It could have been measly me. When you're there in the heat of the moment, they were, the defense was mistrial, declare mistrial. Man, you don't want mistrials because I'm telling you, they fix the case. The prosecution fixes the cases, man. All right. We talked about Daybell as well. So we got Read. Now let's talk about the big hearing coming up tomorrow and possibly into Thursday. It's the Bryan Kohberger case, right? Now, we've gone through a lot of these motions, okay? A lot. I think we've talked about on the beginning, literally just about everything, all right? And the court, the only recent order that was issued today was the court having before it a stipulated motion. Stipulation just means an agreement amongst the parties to seal defendant's notice regarding expert disclosures, exhibits D7-B and good cause appearing. Now, therefore, it's ordered that is sealed. It's going to come out tomorrow. All right. I like the judge that we have in the Bryan Kohberger case now. He is no nonsense. He's moving this case along. He's the one that said, why are we sealing everything in this case? Everybody has a right to know what is so special about this particular case, which was the same argument that I've been saying as it related to the Lori Vallow, Chad Daybell trial. Everything was so secretive. Oh my gosh, we can't do that. And then it comes out of trial. What? Is that it? I've never seen anything like that in anywhere that I've ever practiced. I'm telling you, go walk in. You got time someday, walk down to your local courthouse. See if there's a motions hearing taking place, okay? I don't care what it is. It could be a homicide trial. You can sit down there and view it. Heck, now in Colorado, they stream everything. We can't record it. We can't stream it, but you can, they have, a streaming channel, so to speak. So you can literally watch the dockets every day. You can watch trials that go on. And you can see everything. You can see what people plead guilty to. You can hear sentencing statements. You can hear, mitigation statements made by the defense. You can see trials. You can see the motions hearing. And, unless somebody requests that it be taken down, for some reason that, they think someone's going to interfere with a witness or something, very limited reasons to do so, you can watch all of those trials. You can watch all of those hearings. And so I never understood why, they have this administrative rule 32I in Idaho that thinks, well, we better seal everything. And I get it. There's certain things that need to be sealed if they contain, medical records, confidential information. I get that. But for the most part, everything else should be public knowledge. And at least Judge Hippler now is on the same page as Crime Talk. So Judge Hippler, thank you. we appreciate you. Okay. And so, like I said, tomorrow's going to be big, ladies and gentlemen. Tomorrow is going to be big, 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 because all of the stage for the Bryan Kohberger trial is set at the motions hearing. All right. What's the judge going to resolve? Well, for example, he's going to resolve the motions in limine regarding the demonstrative exhibits. Remember, the state wants to bring in their big model. Remember all those measurements that they took before they tore the house down? Couldn't understand exactly why they were going to tear the house down, but the people that own the house wanted to donate it to the city, wanted to move along. I don't know. If I rented the place, if it was my house, I would have called in those people that clean up crime scenes and rented that place out again. But these people apparently had so much money that they donated it after, and then the university tore it down. Now, the defense was given a lot of opportunities to go in and measure it and take all the photos that they wanted to, not once, but twice, I believe. The second time was right before it was going to be torn down. The prosecution did the exact same thing. And, they have all these big things. I mean, you can do crime scenes now. They stick it out there. It's like this big GPS thing, and it tells you the distance and measurements of everything, and they can do it all, right? And so the prosecution said, yeah, we could do it the old-fashioned way. We could just give you pictures. Here's the picture of the house. Here's a picture of walking into the house. Here's a picture of walking into the hallway, into the house, going to the bedrooms. It gets boring. They drone on, right? So they said, let's do something kind of unique, right? We got a bunch of money from the county treasurer and things like that for this special budget for this big trial. It's a death penalty case. Let's go big. Let's create a 3D model of the house so the witnesses can say, okay, here's your little point saber or little stick, and here's the house right here. Where's your bedroom? Oh, can the jury see that properly? All right, let's take a look at that. And so that's your room, right? And then you went down here, and then you saw the big bushy eyebrowed guy, right? And then everybody in the jury box is going to look over at Bryan Kohberger and say, "Oh, big bushy eyebrows, huh? Do you think they're going to shave his big bushy eyebrows?" I don't know. No, I'm not saying as a defense attorney you would suggest such a thing, right? But, you can always tell your clients to, you maybe want to shave that beard for trial. There's some negative connotations to wearing beards at trial. There's psychology evidence that you're hiding something. So, you can suggest that, maybe get a little trim, get a haircut. Never hurts to look good when you're in court, right? He's got his suits that he's going to be wearing. Obviously, he's entitled to wear civilian attire while he's there. But they got the 3D model. The judge is going to decide whether that comes in. The defense is objecting to it. Why? Why is the defense objecting to it? Because they didn't think of that. I mean, are they saying it's not to scale? It's ridiculous, right? And if I was the defendant in this case and I was the defense attorney in this case, I'd be like, okay, really? Okay, I'll object, Your Honor. God, they have a much better idea than we did. And they got this 3D model. It's really cool. But you know what I would do? I would embrace it. And I would say, every witness, let's go ahead and take a look at the government's demonstrative exhibit. Why don't you come over here to the 3D model and use it to your advantage? Embrace it. The bad facts, embrace it. The model that's going to make the prosecution look better than you, embrace it. Use their own model. In fact, it's a demonstrative exhibit. It's not coming back into evidence unless everybody, agrees that, it's fair enough. But they can't. It's not like, remember you used to have the big flipboard, draw a chart here. Yeah, we go ahead and, draw this not to scale of the house or the room or whatever it was, right? That normally didn't go back into evidence. Or if it did, or if they already made an exhibit, but then they had somebody mark on it. I used to do this all the time. They would bring in this big board of an exhibit, right? And it's like, okay, detective, do that. Why don't you go ahead and put a mark right there? And next thing you know, I'm completely vandalizing the prosecution's exhibit that's now been altered. Oh, sorry about that, Your Honor. But look, he put it different than what they said it was going to be. So let's put little different colors and stuff on here. Use it to your advantage. Kohberger has experienced attorneys. All right. Another big motion that the prosecution and the judge and the defense are going to resolve, right? The self-authenticating records. That's right. Are they going to be able to bring in the facts of Mr. Kohberger's shopping adventures that he went on, where he would buy, for example, a K-bar? I mean, let's face it, ladies and gentlemen, unless you're giving these as gifts, a K-bar, I better put that down. Don't want to freak anybody out. We'll keep it in the sheath as well because it's live. They have rules against that. But think about it. You buy one of these once in your life, okay? I guess maybe if you lose one, that would be another reason to buy one. Allegedly, what Bryan Kohberger did, tried to buy another one once he realized, oops, I maybe lost the sheath, right? Because he's not a dumb guy. We know what he'd be looking for. Hell, they're trying to introduce his exam. We did a video about that. I think was the end of last week or week before. I can't remember exactly, where he talks about his final paper and how to think like, obviously, a crime scene investigator. What would I do to preserve the evidence? What would I do to make sure that the defense couldn't do this, this, and this? And then you realize, damn, I can't find that damn knife sheath anywhere, allegedly, right? And so what do you like? I guess I better find one, right? Because if they come looking, where's your knife? Oh, right here, right? I mean, these knives haven't changed in literally 70 years. All right. If you look at a K-bar from World War II, it's going to look just like this. Or you buy one, go down to your local Cabela's or buy it online at Amazon. It's going to look the same. You're going to get the sheath. It's going to have the little eagle, globe, and anchor there. I don't know if you can see that. Okay. It's got this leather grip here, and it's going to have the knife sheath, right? You can put it on your belt. Like, why wouldn't you have this on your belt or tape it to, something so you don't lose it, right? And then it's going to have the little snap up here, and it's kind of hard to snap, right? Okay. And like I said, you only buy one of these unless you lose it and you really, really need it. I got this. I went to Marine Corps boot camp I reported 14 June of 1988. I remember that date. It will forever be ingrained in my mind. Okay. I can tell you, my senior drill instructor, Staff Sergeant Quinones, there are certain things that you remember. And then, as every Marine knows, particularly if you're going to go into combat arms, you're going to get a K-bar. Not that it's any particular great, but frankly, I find them very hard to sharpen. It's probably one of the last knives I would want to use to attack anybody, but the historical significance of the K-bar, every Marine has one. When you go to a different command, they give you a K-bar when you leave, right? You retire, they give you the plaque with the K-bar on it. That's what they do. It's significant to the Marine Corps, right? So there it is. So I've had this since the summer of 1988. How many years is that? Somebody do the quick math. 36 years? Oh my God. My God. How many years ago is that, Frank? That's going to make, Frank, help me out here. Let me do the math, right? 2025 minus 1988. 37 years, ladies and gentlemen. I have had this knife for 37 years, for God's sakes. And I have managed to take it to the field. I have managed to take it to the desert. I've managed to take it to cold places as well. For 37 years, ladies and gentlemen, I was able to keep track of it. Now, maybe as a Marine, you're taught keep track of your gear, right? Lose your gear, don't have your fighting instruments. Bryan Kohberger, allegedly goes into this house one time and loses his gear, right? But they teach you those things. Maybe if Bryan Kohberger had gone to Marine Corps boot camp, he wouldn't have lost his gear, assuming it's his gear, all right? For all the Bryan Kohberger's innocent crowd. I'm just talking to the Bryan Kohberger is guilty crowd, I guess, right there at this very moment. But if is he in fact guilty as charged? If he is, we'll give him the presumption of innocence. He lost his gear, right? I mean, do you ever, it's hard to describe, but if you ever seen Full Metal Jacket, that's probably the best example of Marine Corps boot camp. Now, they're not supposed to punch you and hit you and all that kind of stuff, but they teach you to lock your gear up, right? You have to take care of it, right? And so there was a scene in there where they, left his footlocker unopened, and then they open it up and it's like, oh, there's a jelly donut, right? Well, normally what would happen is, you do your morning stuff, you'd head out and everybody would lock their footlockers up and you go off to chow, right? And you come back to chow and you would find footlockers completely strewn about in the squad bay. Why? Somebody left their footlocker unlocked. And so the drill instructors would dump it in the center. And of course, the people would be given just a couple of minutes to goodbye. But what that taught you was you don't leave until you check your footlocker to make sure it's locked. Just like when you leave a hotel room, you make that final pass, make sure you don't forget anything. Bryan Kohberger allegedly left his sheath to his K-bar there. I've managed to hold on to this for 37 years, and Bryan Kohberger can't even keep track of his own gear for less than a year. Embarrassing. Obviously, he's not a Marine. Learn to you learn to take care of your gear. I have a pen that was given to me when I graduated from law school, ladies and gentlemen. 1995. Have a pen from 1995. Keep in a nice pen case with all the other pens that I have. I don't lose pens. I just don't. I lost one once in Nebraska in a simulator. I was trying, my pen fell out. A Porsche pen, I might add. It looked just like this, but silver. And they sent it to me. So that's it. All right. So the self-authenticating documents, the judge is going to rule as a matter of law whether these are going to come in. Now, the objection can still be made at trial, but that is the way it is. And they can introduce these documents, and they can have. I mean, I still think I'd bring somebody in from Amazon to explain, how do we know that Mr. Kohberger is the one that purchased this item, and I don't know, not his sister or his father, right? Well, what was they can explain that, well, we know that because the shipping address is where it went to, and the billing address, and all those types of things. That, ladies and gentlemen, is going to be a tedious and methodical part of the trial, but it is coming in. The other thing as it relates to is the surveillance footage, right? The 1320 Linda Lane surveillance footage, the 1330 Linda Lane surveillance footage, the Albertsons video surveillance and business records from November 13th, the Amazon financial records for Bryan Kohberger regarding his click history. Now, the prosecution can say, oh, you can't really trust that click history. And Amazon say, no, you can trust it because we rely upon it to make sure our records are accurate and maintain. Well, you're going to check out. You bought that knife. Everybody knows K-bars suck to be sharpened. So you might as well get a sharpener with it. I'm telling you, this thing, after 37, I guess I could probably cut myself with it. I mean, I guess I could probably, see, it barely even cuts the paper. Barely. I'm telling you, these are terrible. Maybe for digging a little hole in the middle of the desert to, do what you got to do in the desert sometime. That was about all it was good for. I have knives that are sharper that I get in my battle box, and which will open up either at the end of the show or for our Patreon members as well tonight. All right. So think about it. Those are the records coming in. AT&T phone records. A Bryan Kohberger. Oh, all that cell phone data, all that stuff that's tracked and logged that all the experts have gone over, and the defense has brought in their expert, the Psy guy, right? And he's supposed to come in and do this, and he's going to create the alibi. Well, it's possible based upon this, and this, that, his phone was on and he was observing the stars at that particular moment. But then you got to deal with all that damn video evidence. That's going to be tough, right? The Cafe Arista video surveillance evidence on November 13th, the Corner Club video surveillance, the Corner Club financial transaction receipts, the Costco surveillance video on November 13th, the DeSale student records regarding Bryan Kohberger, the Dick's Sporting Goods records for sales of Bryan Kohberger, the mask, oops. And although the defense never has to do anything, if the question is asked in detective, you see this purchase and it's anything significant about that? Well, it's significant because the witness said that he was wearing one that would be similar to what this purchase indicates. Okay. And were you involved in the search warrants of Mr. Kohberger's car? Yes, I was. Did you happen to find that mask in his car? No, I did not. Were you involved in the search warrants of his apartment? Yes, I was. Did you find that mask? Obviously, the answer is, well, yes, we did, or no, we didn't. And of course, the people in the jury are going to say, well, that's funny to buy a ski mask and a knife just like that and all these other clothing items to keep contamination of leaving physical evidence, right? Right? They're going to say, I know the defense doesn't have to do anything, but I'd sure like to know where that is. And, ladies and gentlemen, let's just pull this out. This is a great book. This is the book. It's called Murder in the Bank Vault. And there was a quadruple homicide in Denver years ago. Somebody else wrote a book on it recently, but this was actually written by Walter Grash. He was an absolute legend in the legal community here in Denver. Recently just passed away. I think he was late 80s, early 90s. But I got to know him when I first started practicing, and I had the privilege of doing some cases with him. Anyway, this was called Murder in the Bank Vault. A former Denver police officer was accused of going into the United Bank building where he had worked as a guard and basically killed 4 people and stole a bunch of money. And he was found not guilty at trial. Anyway, one of the things that they had to deal with was identification. And they always put up various people, right? They describe certain people. I don't know if you can really see that, but I think it's always interesting to show that. And they kind of did some studies and saying, okay, that's the description you gave. The guy was wearing a hat. Okay, yeah, the guy's wearing a hat, glasses, a mustache, right? So that's him, right? So it looks like, 4 discrete people. And one of the experts was a lady by the name of Edith Green, who I've used before. She's a gun focus person. So, but then you take a look at it, you take away the mask, and who do you have? You have Lee Iacocca, Marlon Brando, Robert Duvall, and Jack Nicholson. So, maybe the defense tried to do something like that, and as it relates to identification, it could be all these other people in here, right? But they also used something which I thought was very, very interesting, and I have used this in the past as well for my closings, particularly when there's a lack of physical evidence. Anyway, this is why, crime scene stuff is so powerful, right? So in that particular case, he reads in his book. He says, I cited the preface to the FBI manual on the need for good police work and examination of physical evidence. I previously read during the trial when I had an FBI agent identify the source of this quotation. Now, remember, this was back in 1991. DNA wasn't really a thing yet. I mean, it was, but wasn't in courts. I mean, I remember doing trials in the military in 96, 97-ish, that you were still doing Daubert hearings on DNA because it was so new. Okay. So I'm sure they've updated the FBI manual, but here it goes. Wherever the criminal steps, wherever he touches, whatever he leaves, even unconsciously, will serve as silent witness against him. Not only his fingerprints or his footprints, but his hair, the fibers from his clothes, the glass he breaks, the marks he leaves, the paint he scratches, the blood he deposits or collects, all of these and much more bear mute witness against him. This is evidence that does not forget. It is not confused by the excitement of the moment. It is not absent because human witnesses are. It cannot perjure itself. It cannot be prejudiced, be influenced by suggestion, by falsely reinforced identity. It cannot be wholly absent. Only human failure to find it, to study, and understand it can diminish its value, right? Great stuff. So you got lack of physical evidence, you pull out that great quote, right? And then you let them know that's from the FBI manual, ladies and gentlemen. Good stuff, right? Defense probably should be thinking about some sort of similar quote like that in the Kohberger case. But they still got to be able to explain that pesky DNA. Right. So we talked about his final exam materials as well. Farmers insurance video, Floyd's cannabis surveillance video, Forex DAX, crypto.com, financial records for him. The Grub truck video surveillance, right, as to the two young girls that were on their way back. Harbor Freight video surveillance, the Idaho Central Credit Union. There's a couple that they're no longer going to use, but there was lots more stuff. I mean, they got every bank record, every video between, Bryan Kohberger's student dorm and where the killing took place there in Moscow, Idaho. PNC bank records, right? Trying to corroborate how did he pay for these? How do we know Bryan Kohberger bought this scarf? How do we know Bryan Kohberger bought the K-bar? Oh, let's take a look at his financial records if you're not satisfied that it was his account. Let's take a look at that. State employees, federal credit union records. They're not going to use a bunch of other stuff, but they got the Sun Mart from Pullman, Washington surveillance video on November 13th at approximately 5:25 and 5:26 a.m., showing the suspect's vehicle in Pullman, Washington after the video. TikTok records. These records are going to show standard chronodal on TikTok applications on November 13th, 2022 at approximately 3:16 a.m. Obviously trying to use that to establish timelines. T-Mobile phone records coming in. U.S. Chef Store video surveillance in Clarkson, Washington, maintained by the business of U.S. Chef Store in Clarkson. The relevant footage is taken from November 13th, 2022. The state may rely on video from the footage at approximately 12:42 and 12:44 p.m. to show the defendant's vehicle and actions hours after the homicide. I wonder if there's a car wash or something nearby there, or a big dumpster. We'll have to take a look. Verizon phone records. They pulled everything, stuff they're not even going to use. The Ulta financial records, Walmart surveillance video, the Washington Department of Motor Vehicle Registration certificate of authenticity as it relates to Bryan Kohberger's vehicle, just to prove that that was his vehicle, right? His driving record, provided defendants was around July of 2023 as part of the grand jury records. Washington Trust Bank records, the relevant state's disclosure for Michael Douglas, Wells Fargo records, Winco financial records, and it goes on and on and on. And then they go through it. And then, like I said, his report, this crime scene scenario final, that's going to go to knowledge. If they try to say, oh, he's just a young kid from Philadelphia, Pennsylvania, the great state of Pennsylvania. He's not sophisticated with those big city ways and crime scene investigation. He no one could plan anything like this out. But unless, of course, you basically say, oh, this is how I'd get around it. This is how I'd make it impossible for the defense, because that's the way they're thinking. Click activity. We talked about that. Another big one, right? The other big one here. The text message testimony, right? We have dueling motions as it relates to text messages that come in. The state's reply is that basically the roommate's testimony comes in. It's not hearsay, but I don't think it really matters because these witnesses are going to be able to come in and testify regardless of whether their actual text messages come in. But the text messages can certainly be used to refresh their recollection. It's not like, it's coming in, ladies and gentlemen. Okay, I truly believe it will come in. The defense will object on hearsay. I get it. I would, objection, lack of foundation, lack of personal knowledge, etc. Calls between the two of them. The call in of itself, the fact that it took place, is not hearsay statement. But I would still make every one of those objections if I was the defense. Objection, lack of foundation, lack of personal knowledge. 401, 403, I'd make them all. The man's life is on the line, right? It's a death penalty case. They're going to object to everything. As to approach, go through all that. The 911 call. Are they going to be able to play the 911 call? The prosecution has taken it upon themselves to literally break down the transcript that the defense had discussed in their motions and explain why every statement in there is not hearsay, right? Remember, what is hearsay? Hearsay. It's an out-of-court statement being offered for the truth of the matter asserted. Sometimes the easy way out and the lazy way out for judges is to say, well, judge, it's not being offered for the truth of the matter asserted. And I always object and say, well, judge, if we're not offering it for the truth and we're not offering for what it's really intended to come in for, then it's not relevant. And then sometimes the district attorney is like, well, and, there's ways of getting around that quite easily without having to introduce the hearsay statement. But oftentimes judges don't really understand the rules of evidence. I know you're saying, Scott, how is that possible? They're a judge. Well, a lot of judges were corporate type lawyers. They didn't do a lot of courtroom work. They always wanted to do courtroom work. Maybe they didn't get to do it. Or there's civil litigators where it's all paper pushing stuff back and forth. How do I get this document in? Is it a business record thing like that, right? But most people that practice that way, nobody thinks about it. Nobody thinks about it. So they just kind of let it all in. Here's a letter that just layers and layers of multiple levels of hearsay on there, do it in. And whenever I get stuck doing a civil trial, there was will you stipulate to our exhibits? No. Will you stipulate to all of mine? Well, maybe if you stipulate to all mine. No, I'll just lay the foundation. You guys try to get it in because, I figured out, you probably don't have all your people to lay that foundation. I remember having to go through that with, a young attorney, had all these records. It was a personal injury case. And it's like, all right, let's go through it. I was like, who are our witnesses? She's like, I don't know. So I wrote on a big blackboard, who is the doctor that treated him? They need as a witness, right? We need a custodian of records to get those documents in. You got to do that all, because it's not just here. I want this evidence into evidence. Please let me do this. It doesn't work that way, right? There has to be an exception to the hearsay rule. And other than the witness coming in and testifying as to what they saw, what they heard, not what somebody else said, what they observed or what they personally said themselves is hearsay, right? So easy way to think about it when you're watching these trials at home and somebody starts talking on the stand about what somebody else said, objection, hearsay. It's not a court statement being offered the truth of the matter asserted. It's hearsay. We want people to come to court, be subject to cross-examination, right? The greatest truth-seeking tool ever created. The Confrontation Clause requires the prosecution to bring the witnesses to court, be subject to cross-examination. We don't do, well, here's a piece of paper, here's my affidavit. No, we don't get to do that. That's weak. It's a lazy way out. We don't get to do that. We're talking about somebody's life here. And that's the other thing that I would be objecting to if I were the defense attorney in the Bryan Kohberger matter. I would object also to confrontation clause. And I say, well, it's a business record. Yes, but the question is it testimonial as defined by the United States Supreme Court? Then it has to be subject to cross-examination. Well, was it made in basically preparation that in anticipation that this could be used in a criminal proceeding? Then it's testimonial. Now, I don't think the judge will go along with that particular argument as it relates to these business records, but you can say, Judge, I've made this argument before. Judge, Amazon, you did not personally download all of Bryan Kohberger's records, did you? You don't do that on a daily basis, do you, in the regular course of your business? Well, no, of course not. It's all saved in a big computer in the cloud somewhere. But it wasn't until the prosecution asked you to prepare and compile all these documents in anticipation of this litigation that you prepared those documents. Well, yeah, I guess that'd be fair to say. So, yeah, I don't know. We'll see. Now, that's probably not going to prevail, but I've tried that because that's what you do. You get creative, particularly when it's the stakes are high. You make them crawl over glass to get there. So we got the 911 call as well, ladies and gentlemen. Are they going to let in the 911 call? Normally, I'll be honest with you, normally 911 calls don't come in. So it's curious as to why they are bringing, prosecution wants to bring it in. I get it for present sense impression. But at the end of the day, have the witness testify to their what they saw, right? We got the transcript of the call, right? I'm not sure why you need it, to be honest with you. You're going to have the people testify. What'd you do? You called 911, right? The defense is going to use this more on cross-examination. Really, let's talk about this. Right? Yeah, you made this call, right? You had this interaction earlier in the evening. You didn't do anything. You're so scared. You're so freaked out. Nobody responds, and you didn't call the police then. No, in fact, you went back to sleep, didn't you? So you don't really know what happens, and you're not even sure if this big, bushy-haired guy was a dream or whether it was something that you actually saw, per your own statements, right? And a 911 call, you weren't sure. You didn't mention it here. You didn't mention it there. The defense is going to use that more than the prosecution, but the prosecution wants it in. And I get it. They think they have a heavy burden, but don't overtry the case. Keep it simple. Ladies and gentlemen, Bryan Kohberger was in the area. We have his DNA. There's 4 dead people. We didn't get him that night, but we, followed the leads. We got the video evidence. He became a suspect based upon a tip that we received. we arrested him. We tested his DNA to the sample there, and guess what? It's a complete and total match. We have evidence that he purchased the items that would be necessary to go in and kill these four people at the Moscow address. And guess what? We have the record showing he bought the stuff, he prepared, he planned for it, and then he got rid of everything as consciousness of guilt. And then he tried to replace the items because he was worried that it would look weird if he ever got onto him and he couldn't produce the evidence. Keep it simple. Don't get too far into the weeds, prosecutors. Sometimes the best time for the defense to prevail is when you overtry your case. Don't overtry your case. Keep it simple. I understand you have a lot, but it's just like when the defendant talks. When the defendant talks, the more likely he says something stupid. He or she, let's keep it fair, he or she will say something stupid, and it will be used against him. And a defense attorney will, the more witnesses you bring up, the more the chances are that somebody's going to say something to screw something up for the prosecution. I remember years and years ago, I had a case. It was a fight at a quinceañera. It wasn't a big deal, but there was a fight at a quinceañera. And if the prosecutor had just called one witness and said, yes, I was at this quinceañera, and that guy over there hit this person because for whatever reason, they bumped into him on the dance floor and he punched him, right? And if the prosecutor had stopped at that one witness, my client would have been convicted promptly by a jury of his peers. But the prosecutor, thinking I must present more evidence, presented like 5 more people. And the story got so confused, and whether it was self-defense, whether it happened or not, whether it was even the defendant. And I swear to God, true story, the district attorney gets up and says, well, ladies and gentlemen, we may not know exactly what happened on this night in question, but we're pretty sure he's the guy that did it. And my closing statement was, ladies and gentlemen, they said they don't know what happened. How do they expect you to know what happened? That is the definition of reasonable doubt. Find my client not guilty, sat down. They went back and promptly found my client not guilty. Okay? Don't overtry your case, Mr. Prosecutor. Defense will pounce. He has very good attorneys. He will pounce. Which is the other thing I want to mention is that, they brought in the new attorney, right? We talked about this. Some people are like, I don't like the way you said his name. It kind of sounds kind of snarky or something. Yeah, probably. I mean, let's face it. This Mr. Hurwitz guy, I don't know him. I'm sure he's a fine attorney. Let's see here. In April of 2022, he was nominated as the United States Attorney in the state of Idaho there. Okay. Now, let me give you some rundown on that. Obviously, the United States Attorney is a political appointee. Most of the United States attorneys are not career prosecutors. They're political appointees who happen to be lawyers. Okay. And so when I say this, I say that back in 2006, because he graduated from Harvard in 2006. So in 2006 and 2007, he worked as an associate at Paul Weiss, Rifkin, Wharton, and Garrison in New York City. I think those are some of the firms that have gone to war with the White House or something along those lines, or maybe buckled to them. Anyway, then in 2007 and 2008, he was a law clerk for a judge, okay, there in the Southern District of New York. Then after that stint for a year, and that's kind of normal, you'd be a clerk for a year, but at least to get you, some idea of what's going on. And then 2008 to 2011, he was associate at Kirkland and Ellis, another big multinational law firm headquartered in Chicago, founded in 1909. And it's the largest law firm in the world by revenue, of the 7th largest by number of attorneys. Their revenue is about $7 billion annually. I'm in the wrong business. Then he went to work at Covington and Burlington in Washington, D.C. Once again, a multinational law firm known as a white shoe law firm, headquarters in Washington, D.C., and advises clients on transactional litigation, regulatory, and public policy matters. Okay. So he does that for 10 years. From 2012 to 2022, he was an assistant United States attorney. So he leaves the big firm. They say, hey, that's good. But if you really want to be a lawyer, you got to be a trial attorney, which means you got to go be in the courtroom. So for 10 years, he served as the United States attorney for the District of Idaho. And then he, like I said, in 2022, he gets to be the guy there. Now, I don't know if he was trying cases. It looks like he tried one. It was a Aryan Knights case, apparently a white supremacist gang activity in Idaho. And he was also the District of Idaho's coronavirus fraud coordinator. So that's him. He went to Stanford for undergrad and Harvard for his law school degree. Like I said, the funny joke is, I think it's funny. I only know a few people that have never mentioned that they went to Harvard, and the list is very few. I assure you of that. And I have the utmost respect for the person that never brings up the fact that they went to Harvard. But the joke is always, do you know how you can tell somebody went to Harvard within the first 5 minutes of meeting them? They'll tell you. That's why. They'll tell you. Okay. I did this trial. It was last summer, and they brought in these guys that they went to Harvard. And I swear to God, for the first 10 minutes, all we did was talk about his Harvard days. And he knows somebody from the office there that went to Harvard. And I was just like so obnoxious, right? Obnoxious stuff. And I said, well, I went to the University of Denver Law School, the Harvard of the West. Oftentimes, some people mistake that with Stanford, but, DU. It's a good private school, good private school in Denver, founded like 60 or something like that. Good school. But so it just bugs me. It just bugs me. But, then I had a professor in law school that went to Harvard and let everybody know that he went to Harvard, and he became a judge. And then he wound up killing himself because he was under investigation for taking government computers and maybe having inappropriate things on them. Right. So I guess my point is, even if you went to Harvard, you're probably smarter than me. I get it. But guess what? You're not going to beat me because I'm going to outwork you. All right. And nobody cares. I was the guy that when he said, where did you go to school? Oh, I went to DU law school. Oh, good. Where'd you go? He goes, oh, I went to Harvard. Right. And I literally said, never heard of it. Drives him nuts. And I don't know what that is. You don't see that with other Ivy League schools. It's only Harvard. I mean, they must have like a how to let everybody know I went to Harvard 101 class in Harvard, right? How to let everybody know I went to Harvard. It drives me nuts, ladies and gentlemen. But hey, that's the way it is. All right. But like I said, I have a family member that went to Harvard, and I swear, never, ever once brings it up. Have the utmost respect for him. And so, yeah, I just, but it's funny to me how they always do that. I don't know what it is. And it's only Harvard. All right, ladies and gentlemen. So we did our hour-long show. We talked about Kohberger, the big hearing tomorrow. Make sure you tune into Crime Talk. We'll bring it to you. I think the start time is 10 a.m., but just, keep checking Crime Talk. Just keep checking. We'll have Karen Reed tomorrow as well. And the Lori Vallow trial continues as well tomorrow. We're going to go to our Patreon show. If you haven't become a Patreon, I think you can join for like $5. And we didn't really have time, but that's right. The battle box has arrived. The battle box has arrived. It's my little box. It arrives every month. Always has something in it. Usually something sharp. Usually some sort of survival gear of some type. It's not a promotion. I just get it. And then I usually put most of it out at the hangar in storage bins, waiting for the great apocalypse to come. That will probably never will in my lifetime, I hope. But if it does, I will be prepared. So anyway, we'll open the battle box at the start of the Patreon show as well. I know you're thinking, God, what's in the battle box this month, Scott? Well, you got to come check us out at the Patreon page. All right. So that's all we have for tonight. Hope you enjoyed the show. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. And I don't think I have any court tomorrow. So I'll probably be with you during the Bryan Kohberger hearing. So come join us. All right. Thanks for watching. And remember, the Constitution matters.